Lesson: Data retention policies and legal implications. Data retention policies are pivotal within the realm of information privacy, serving as the backbone for managing how long organizations maintain personal data and under what conditions they dispose of it. These policies not only ensure that data is kept only as long as necessary, but also safeguard against legal ramifications that could arise from improper data management. A robust data retention strategy is indispensable for compliance with legal obligations and enhancing organizational efficiency. At the core of data retention is the principle of data minimization, which mandates that data should only be retained for as long as necessary for the purposes for which it was collected. This principle is enshrined in major data protection regulations, such as the General Data Protection Regulation in Europe, which articulates that personal data must be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. 266679. Non-compliance with such regulations can result in hefty fines, as evidenced by the €50 million fine imposed on Google by the French Data Protection Authority, CNIL, in 2019 for lack of transparency and valid consent regarding ad personalization. A practical framework for developing data retention policies involves several actionable steps. Firstly, organizations must conduct a data inventory to identify the types of data they hold, the sources, and the purposes for which the data is processed. This stage is crucial for understanding the data landscape and setting the foundation for a retention schedule. The mapping of data flows can be supported by tools such as OneTrust or TrustArc, which offer comprehensive solutions for data inventory management. Once a data inventory is established, the next step is to define retention periods for different categories of data. This should be guided by legal requirements, business needs, and industry standards. For instance, financial records may be retained for 7 years to comply with tax regulations, while marketing data might only be necessary for a shorter duration. An effective approach here is to develop a data classification matrix that cross-references data types with applicable legal standards and business requirements. This matrix acts as a living document that is periodically reviewed and updated to reflect changes in laws or business objectives. The third step involves drafting a data retention policy document that clearly outlines the retention periods, the rationale behind them, and the procedures for data deletion. This document should be accessible to all employees and form part of regular training sessions to ensure organizational awareness and compliance. Incorporating case studies in training can enhance understanding. For instance, a review of the Facebook Cambridge Analytica scandal reveals the pitfalls of inadequate data governance and the importance of rigorous retention policies. Legal implications of data retention policies cannot be overstated. Organizations must ensure that their policies are not only aligned with regulatory requirements, but also adaptable to legal changes. For instance, the California Consumer Privacy Act and its subsequent amendments have introduced additional data management obligations for businesses operating in California, emphasizing the importance of staying updated with legal developments. Legal tech solutions such as Termly or Simple Legal can assist organizations in tracking changes in legislation and updating their policies accordingly. Moreover, organizations should implement technical and organizational measures to enforce data retention policies effectively. Automated data deletion tools such as Varonis or Spirion can be employed to ensure data is securely erased once it reaches the end of its retention period. These tools also help in demonstrating compliance during audits, as they provide logs and reports that can be reviewed by data protection officers or regulators. To illustrate the real-world application of these strategies, consider a multinational corporation that, following a data audit, discovered inconsistencies in its retention schedules across different regions. By implementing a centralized data retention policy and employing automated tools for data deletion, the company not only streamlined its data management processes, but also mitigated the risk of legal penalties associated with non-compliance. This case exemplifies how a methodical approach to data retention can yield significant compliance and operational benefits. In conclusion, effective data retention policies are essential for managing the life cycle of personal data in compliance with legal requirements and organizational objectives. By conducting thorough data inventories, defining clear retention periods, drafting comprehensive policy documents, and utilizing technological solutions, organizations can navigate the complexities of data retention with confidence. The integration of practical tools and frameworks ensures that these policies are not only theoretical constructs, but actionable strategies that enhance data governance and protect against legal risks. As data protection regulations continue to evolve, organizations must remain vigilant and adaptable, ensuring their data retention policies reflect the latest legal standards and best practices.